My name is Josh Schneps. Our company is Schneps Media. We publish many of the local news outlets throughout New York City and Long Island, even into Westchester. And this morning is part of a series of webinars that we're going to be doing under the corporate umbrella Straight Talk webinars. And our goal is to bring experts that can inform you guys and give information to our readers. And obviously, we're in the midst of something that none of us could have ever expected. But, Ron has spoken at several events that we've hosted, never a webinar, right, Ron? This is the first webinar we've done.
First one.
But he is an expert at wills and estate planning, and, it's always important. But obviously, during this crisis, it's something that we feel was a critical topic for people to understand, ask questions, get answers. Ron's going to do his best. We're going to go through a whole series of questions and answers, and people can ask questions, as I stated before. But Ron is also available. Everyone will be getting his contact information after this webinar. And I'm sure Ron would be happy to hear from you and be able to see how he can help you and your families and even business planning. It's not just personal.
Absolutely.
Yeah. So, with that, Ron, why don't you just, introduce yourself, let people know about you and your firm, and we'll take it from there.
Thank you so much, Josh. And again, I just hope everyone out there is doing as well as you can during this crisis. If you have a loved one that's in the hospital or been stricken with this, just a safe and speedy recovery. And my condolences, because unfortunately, we all know somebody who's passed away from this dreadful disease. Anyway, my name is Ron Fatoullah. I have a law firm that does estate planning, elder law, special needs planning. The name of my firm is Ronald, Fatoullah & Associates. We have a dedicated team of around 20 staff members. We have 7 attorneys, and we're there to help everyone during this crisis. And before we get into it, Josh, I just want to make one quick statement. This is an unprecedented time to plan. Long-term care rules are changing, but if you plan now, you could get ahead of the curve and not be affected by the changes. It's an amazing time to do estate planning, estate tax planning. Values are lower. It enables us to reduce, or in most instances, eliminate estate taxes. So it's an awful disease, but it does provide us with unprecedented opportunities to plan at this point.
Thank you, Ron. Yeah, I think at the end of the day, we all need to be planning. And I think what's happening with this crisis is, as you were saying, we're all in terrible situations where we know people that are not well, that have passed, that are fighting this. We're reading it in the news. We're covering it in our news outlets. But I think it's always important, but now it's really top of mind. So if anything, I hope that something positive comes out of this for all of us, is that you're able to plan for you and your families. So I think, to start off, it goes right into our first question. In light of the current crisis, what documents are the most important to have in place?
Okay, with this crisis, people are becoming ill. People are actually starting to realize, we all know it, but we're starting to realize that we're mortal and we really need to do this planning. So number one, and I would say this is number one, is a good, specially drafted power of attorney with special provisions in it for long-term care planning and estate planning, not a form. It's a power of attorney that enables you to appoint someone else to do your planning, not just write checks, do your planning. For example, create a trust if needed. If you're in a hospital, we just got this call. Client is in the hospital, got the call from the husband. His wife is in a hospital on a ventilator. What could we do now? Well, I said, does she have a power of attorney? Does she have a healthcare proxy? And the answer was no. I heard you talk. I heard you lecture. we were thinking about it, but we just never did it. It's an issue. So I hope that this talk really motivates people to do the planning that they need. But number one would be a very good power of attorney where an individual could appoint someone else or several individuals to make their financial decisions and do planning. We need to add about 40, maybe even 60 or up to 80 extra provisions in that power of attorney so that individuals could plan broadly and not be hindered at all. So on the financial side, that would be a good power of attorney, a special planning power of attorney, along with a statutory gifts rider. That's a New York State statutory rider that's added to that power of attorney to open it up so that we can do the planning, and we'll add extra provisions to that as well. So number one, we don't want anybody to be stuck because they're ill, because they're in a hospital. Just, you can cherry pick, hand pick who you want to name to handle your affairs. You could set forth what you want them to do. They must abide by your wishes, but they're going to be stuck without a very good planning power of attorney. And if you don't have one, we have to go to court and have a guardian appointed. So someone else has to make those decisions. But you can imagine at this point in time, we still can go to court, but they're not hearing most cases. They have to be special cases. Individuals, I believe, would be stuck to a large extent without the proper documents now. So number one is a good special power of attorney. Number two is a healthcare proxy, where you appoint someone else to make your healthcare decisions if you can't make them. It's extremely important. Who's going to make those decisions? Well, you should handpick who that individual is, and you should let that individual know exactly what your wishes are from A to Z, and they will make those those decisions for you if you can't make them. And be sure to name a successor. Absolutely crucial to have a successor agent on that healthcare proxy. I would say number three, not in order of importance, but I'm going to get to what I think is one of the most important documents. But number three is a will. You want to make sure that your assets go, God forbid, when you pass away. And we're seeing people, unfortunately, die of this. And, you know, someone close to me has passed away about a week ago from this damn virus. But where do your assets go when you pass away? Well, the will set forth where your assets go. But if you're smart, you will also have a living trust. And if you're smart, the trust, if the assets are held by that trust, will set forth where your assets go when you pass away. And with that trust, you can do a slew of planning. And that's what I hope individuals do. Plan now, plan for long-term care. Buy long-term care insurance. If you don't have the insurance or can't get it, or it's too expensive, or you're not qualified physically, you have a physical issue and they won't give it to you, do Medicaid planning. Now is the time. The laws, it's on the books. Just 2 weeks ago, the laws changed. Do the planning now ahead of the curve before you're going to be knocked out, and maybe you're going to have to wait a long time to get the care that you need. So I'd say a living trust is absolutely crucial. I would say that's number one for most people, but a power of attorney, crucial. Healthcare proxy is crucial. Making sure you have a will. And the last document I would say is a living will. That's a document where an individual sets forth what his or her healthcare wishes are. Someone might say, I don't want to be kept alive artificially if there's no chance of recovery. Somebody might say, I do want to be kept alive. Put that down in writing. It'll make it much easier for the proxy to make decisions when that proxy sees what your wishes are in writing, staring at him or her in his or her face. So those are the documents that I think everyone should have, along with a long-term care plan, and with an estate plan. Everybody's situation is different, has to be fluid, but especially now, it's an unprecedented time to plan.
You know, Ron, this is all terrific information. We're getting questions that are flowing, and I'm just going to throw in a few because I feel like you could direct them easily. But
Absolutely.
do any of these circumstances change by state and or by even if people live outside the U.S. or are working outside the U.S. now?
Yes, I mean, that's such a broad question, but the answer is yes, things are different in other states. Governor Cuomo gave us many executive orders, but a few that affect what I do as an elder law and estate planner. Well, we could now notarize documents virtually. We could witness documents virtually. And that was a very recent executive order, but everything could be done virtually. But for the notarization, I mean, there's certain requirements that the individual has to be in New York. Many other states have joined the bandwagon on that, but various states have various requirements. But I will say this, if you do the document in New York, it's good in New York for sure. Is it good in another state? Yes, it's good in another state as well. It's very important. It may not be a statutory document in Wyoming, if that's the state that you're interested in, but it's a valid power of attorney where or a valid healthcare proxy. In other states, they may call it a power of attorney for healthcare decision-making. It's valid in all those other states, but it might be better to also have documents, if you're going to be spending lots of time in another state, have documents that are more easily recognized in that state. But definitely, if you live in New York or you have a residence in New York, make sure that you have New York State documents. They are good in other states as well. And a will, for example, signed in any state, as long as it's validly done in the state you signed it in, is good in every other state, all 50 states.
Great. You were touching on this, but how can these documents be signed in light of the social distancing requirements?
It's a very good question. And, initially, Josh, we were not getting as many calls in because people were saying, well, I need to go and see my attorney. Then I need to see the documents. And then we got to get them notarized and witnessed and signed. So we're going to wait. Even though I know I shouldn't wait, we're going to wait. Well, no, things are really now very different in the last few weeks. Governor Cuomo signed these executive orders. And this is how it's handled, at least, with my firm. We do our consultations virtually in a meeting like this, where I could see the client and we can just chat. It's just as good as if we were in my office or the conference room. And again, we have 7 attorneys and we're doing this all the time at this point. Number 2, documents are sent for review, and we have another Zoom meeting or FaceTime where we go over all the documents. It's just as good as if someone was in the office. But number 3, with these executive orders, it's easier now than it's ever been to sign documents. You don't have to go to the attorney's office. You don't have to look for a notary or witnesses. It all could be done virtually. So for the first time, it's unprecedented. You could sit back in your living room and just get everything done. How easy is that? So with the virtual notarization that came out first, I would say almost about a month ago, the governor had set forth these requirements. So number 1 was that there was a video conference that the attorney and the notary and the client would be involved with. Well, that's pretty easy to set up now. Everybody's a whiz at this right now. The individual will show ID if the individual is not known to the notary. And then there are certain safeguards. That document is signed. It has to be transmitted. This is one of the items, along with the witnessing. The witnessing is very comparable to this, but that's a new executive order. But one of the requirements would be that the document, after it's signed, has to be transmitted. Could be electronic, it could be hand delivered, but it has to be transmitted the same day to the notary or to the witnesses. And that could be done. It's just so simple today. You just take a picture on your cell phone. That's it. It goes back, might take a minute or two, but how easy is that? Goes back, it gets notarized. And then we could do an original notarization. So how simple is that? But these rules are only in effect until May 7th. Do I think the governor is going to extend that date? Yes, but there's no indication that that's happening right now. So right now is the time to do this. It has never been easier because now this could all be done while you're at home. So this is how it works, and it's unprecedented. It's never been like this. And I would venture to say that our world is going to change once we get back. And I would be surprised if some of this doesn't get codified as law down the road. But for right now, these rules are good until May 7th.
Great. I know we still have a lot of questions flowing in, but I think you're going to answer some of them throughout this, and we can always catch up to ones at the end. Who will make my healthcare decisions if I wind up in the hospital?
You know, it's funny, I'm getting chills down my back because I get this question at this point in time from people that I know, clients that I love. It's been an emotional roller coaster. But if a loved one is in the hospital and you have a healthcare proxy, you cherry picked who you want to make your healthcare decisions. They know what your wishes are because you had conversations with them and you have a living will, hopefully. And that's simple, that's easy. But what if you don't have a healthcare proxy? I had that call recently. So what do? My wife is on a ventilator. I know, she told me what she wants. We don't have a healthcare proxy. I heard you lecture. What could we do? Take a deep breath. There is a way around this. If someone is in a facility, such as a hospital or a nursing home, and it's a fairly new law, it's called the Family Healthcare Decisions Act. Dick Gottfried, a New York State Assembly person, spent almost 20 years trying to get this through. It's law now, as of several years now, but it took so long. And I met Dick recently, and I was joking with him about how long it took to get this out. But if you have a loved one in the hospital, this law says if you don't have a healthcare proxy, there's a pecking order, spouse, children. It even goes down to a best friend or a close friend could make your healthcare decisions based on what your wishes are, number one, and number two, if they don't know what your wishes are, what would be in your best interest? So there's this safeguard now if you're in a facility, if you don't have a healthcare proxy. But make sure you have the proxy. It's easier, it's simpler. And what if you're not in a facility? You could have your healthcare decisions made. We have so many clients who are at home, and you know, they're shivering all night long. They're going through these convulsions, and it's awful. And some decisions have to be made. Just have that proxy. It's simple. It's easy. Just make sure you have that done.
What about finances, Ron? If you end up in the hospital, who would handle your finances?
That would be the agent or agents on that power of attorney. But again, you want to make sure that you have a very broad power so that planning could be done, not just writing checks, although that's important, but you want to make sure that everything could be done because special planning, with jockeying assets back and forth, may have to be done now, right then and there. So you want to have that broad power of attorney. But if you don't have that power of attorney, that's where we may have to go to court and have a guardian appointed. Now, it's very interesting. The governor, in one of his executive orders, in fact, the same one that permitted us to do the virtual notarizations, said that if you were diagnosed with COVID-19, you could actually set forth and declare a standby guardian. Like, it's a very temporary measure and it's limited, but you could actually declare someone to be your standby or temporary guardian so they could make decisions for you. I mean, it's a short paragraph. We don't know exactly how everything is going to work out. Make sure that you have your documents in place, but the governor, I think, is doing an amazing job in light of what's going on, and he actually thought about this as well. So an individual could designate a standby guardian if they've been diagnosed with this disease. Yes, and that's what's going on. It's just absolutely crazy because things are changing by the moment. Yeah.
Typically, we can't do it here, Ron, but typically at our events, we always ask people to raise their hand if they do not have a will. And every single event we have blows my mind how many people do not. And you were talking about even, some people that that are sophisticated and just don't have all these documents. But share with us what happens to someone's assets if they do not have a will.
That's a very good question. If if you don't have assets in a trust and you don't have a will that sets forth where your assets go. So if there's no trust that sets forth where your assets go and you don't have a will, well, in essence, New York State writes that will for you because there's a law, the Estates, Powers, and Trust Law that goes over trusts and everything, but it also sets forth where your assets go if you don't have a will. And assets are not directed by a trust or a beneficiary designation. Where your assets go are dictated by the law. And the law says, for example, if you have a spouse and children, the spouse gets the first $50,000 and then it's split between the spouse and the children. Well, that's what New York State is guessing an average person may want. But think about it. What if your spouse needs your assets to survive? Well, the spouse is only going to get about half. That's not what you want, but that's what's going to happen if you don't have a will. What if there's a child that you're estranged from and you don't want that child to get anything? That child will get, because you don't have a will or a trust and you didn't name your beneficiaries correctly, or you don't have any designations. So the list goes on and on. If you have children and no spouse, the children get everything equally. But for example, let's say you have a disabled child. Those assets should be held in a trust, but they would get outright. And what if you don't have a spouse, no children, and you have parents? Well, even if that parent is on Medicaid, they would get the assets, and then they would have to go off Medicaid. I can't tell you how many times that has happened. But what gets me, people that don't have close family members, their assets will go to distant relatives if they have distant relatives, and people that they've never even spoken to. It's crazy. Make sure you have a will. Set forth what your wishes are as far as where your assets go when you pass away. Preferably, you'll have a trust and you should have a will. I saw someone who asked, is it better to have a will or a trust? Well, it's better to have a trust, but it's even as my young child, when my son was younger, he said, well, what's more better? It's more better to have both, because you want a will just for any stray assets that don't make it into the trust, but then you want your assets in the trust. And that trust would be so easy. For example, if God forbid there's an issue, not even when you pass away, but beforehand, you're in the hospital, everything is held by the trust, and it's just managed by the trustee or the successor trustee. Everything is under one roof, and we could control it. It's easy, and it's really the right way to do. But you would want both a trust and a will. You really do want both.
Well, that flows into the next question, but I want to address something, Ron, because we're getting a lot of questions. And
oh, good.
the question that I keep getting is about getting online documents for wills. Now, I'm not the attorney here, Ron. I'm going to let you answer. But I would tell you, anyone that's listening, I know it's tough times financially, but this is your assets. This is everything you have ever worked for and everything you want in your life to go to probably a significant other or children. This is why we have Ron here. He's a professional. He's an attorney. And I personally can't stress enough how important it is to have an attorney walk you through this process and do it from beginning to end. Because once you're not here, there's nobody else to back you up. So Ron, please address it. But I mean, I feel like, this is something, it's like buying a house and having a will are probably two of the biggest financial decisions people make. And I can't personally stress how important it is to have a professional do it on your behalf or represent you.
Josh, I could not have stated it better than you did, but I could just give an example. The last case that we had where someone did a will on LegalZoom, it was in Queens. It was the worst experience that we ever had. Typically to probate a will, it's, it could be a few $1,000s, but it's not crazy. There were so many issues that arose from this will that this client did. Well, the client we got after he passed away. The legal fees were so high because the will wasn't executed right. When an attorney drafts a will, forgetting about the document itself, when an attorney drafts a will, there's an actual presumption in the court that the will was signed the right way. And somebody has to rebut that presumption. And it's not easy. It's never, ever happened to us in my 40 years of experience, ever. But with this one LegalZoom will, it wasn't signed exactly right because one question wasn't asked the way it should have been. And the will was contested, and I couldn't believe it. But of course, we gave the estate a break on our legal fees, but it wound up to be actual time charges with $65,000 instead of just a few thousand to probate the will, because it was such a crazy, crazy mess. So just by the fact that an attorney is doing it and it's supervised by the attorney, you get that presumption, and it makes things so much easier later on. But that's just number one. Number two, the attorney gives it more thought, would draft it a certain way to make sure it's exactly what you want. And oftentimes in that will, we would actually have a trust. There are living trusts, but there are testamentary trusts. Let's say a client comes in who's 75 years old and wants to give some assets to grandchildren. Well, why don't we do a trust for those grandchildren? Do you want them to get all that money at age 18? I don't think so. So we could do a trust, simple trust within that will, so that they might get a third at age 21, a third at age 25, or however you want it, a third at 30, whatever you want. But that will be thought about. We'll go over everything. And if for no other reason, you get that presumption, and that means everything later on. And it's like that with other documents as well. When attorney supervises it, for example, with a power of attorney, if there's an issue with the power of attorney and a bank has an issue, and sometimes they do with all powers, we get a call from a bank, they talk to us, they said, oh, it's you, no problem, and that's just the way it works. So, for example, in the powers of attorneys, we must add 40, 60, sometimes even more provisions into that power of attorney in a statutory gifts rider based on your situation. You're not going to get that online. It just won't happen. And as Josh said, you work your entire lifetime. You just want to make sure that while you're living, if you have a healthcare issue or you become incapacitated, or God forbid, when you pass away, you want to make sure that your assets are going to be there for your loved one just the way you want them, with no headaches. So I can't emphasize how important it is to have the right type of plan and then have the documents that implement that plan clearly. And once you do that, I would venture to say, because I hear it from all of my clients, you do the plan, and now clients come in nervous and they go out when the plan is done, the documents are signed, they just feel like, you know what, check, that big check, as you know, on their to-do list. It's done. I feel good. It's done right. We thought about it. All the issues that I wasn't sure about were, you know, all the questions were answered, and I am set. And that's a huge relief when you know that you have control. You know, I don't dictate what that plan is, but what my firm does is we give you suggestions. We make recommendations. You don't feel comfortable with X, then we're going to do it. Maybe we'll do Y. But you're going to have control, and you're going to feel much better. How much better you're going to feel when you know your assets are protected and they're going to go the way you want them to go when you pass away, and protected during your own lifetime in case you have a long-term care need, etc. So it's a huge relief for almost everyone that has gone through the process.
Ron, we were touching on the living trust. So what are the advantages of having the living trust?
The advantages are huge. So I have alluded to long-term care planning. So for many people, and I would venture to say we get more calls on this than anything else, people want to do Medicaid planning. And the laws are changing. The laws are changing soon. This just happened this month in April, a couple of weeks ago, when the governor signed the budget, the law changed. We now have a new look back for home care. Used to be there was no look back, and that's effective October 1. But right now, transfers or gifts are going to be affected by this. So you want to do the planning as soon as possible. Get in there. And, you know, because there's this look back, make sure that you get in now, start that look back, which I could explain later on. But number one, we do trust for long-term care planning, and it's amazing how well this works. We call it a Medicaid Asset Protection Trust. Assets go into this trust. You could get the income on your assets. Terrific. You can live in the home if the home is in the trust as long as you want. The home could be sold. You preserve your capital gains tax exclusion, that $250,000 or $500,000 capital gains tax exclusion. There's a basis step up upon death. You get everything that you would want, but the home is protected, and it goes without probate later on. And any assets in any trust will go without probate later on. So we use these trusts for asset protection for long-term care. For our clients that have a decent amount of assets, we use trusts to save on estate taxes. We might do what's called an estate tax freeze. That's where assets go into a trust, and let's say now when your real estate is at a lower level now, your portfolio is at a lower level, the stock market has these 1,000-point swings every day, which is not uncommon, very volatile. But, you know, as your assets go down, it's an opportunity to freeze your estate at these lower levels and let your assets grow outside of your estate. And there's a way to do it where you're getting money in for the rest of your life. So that's for our clients that are wealthier. So it's for Medicaid planning, for estate planning, to avoid probate. People don't realize, for example, they say, okay, so we'll go through probate. It's not a dirty word, and it really isn't. You know, we have a very robust probate department in our firm. We do these cases all the time. But if you could avoid it, that would be much easier if your assets are held in a trust. But think about all of the individuals that have assets, let's say a condo in Florida. Well, what does that mean? Well, you have to go through probate in New York, and then you have to go through ancillary probate in Florida, you know, or wherever, what other state you may have a piece of real estate in. It's crazy. There's such an easier way to do it. You might as well jump on that bandwagon and make sure that you have a living trust. And as I mentioned, you could give to grandchildren over a period of time that you specify. Or let's say with a trust, you could give assets to a beneficiary, like let's say a daughter that may not be good with money. She might blow it soon. So you have these assets held in what we call a spendthrift trust. It's another reason to create that trust. But you could actually have one trust that protects your assets for long-term care. It could actually even do some estate tax planning. You can incorporate in that trust an SNT for or a trust for a disabled child, for a spendthrift child, for grandchildren, etc. So you could have this all set up in one trust. One trust could actually serve multiple purposes. So those are the basics, but one big area that people just don't talk about, if while you're living, you have assets, let's say in a revocable trust, and you become ill, or you're in a hospital, the trustee just takes over, you know, and that continuity of management, you don't even have to show a power of attorney, it makes things just so easy. Everything is there, like I said before, under one roof, and you have that continuity of management of those assets, even in the event of incapacity at this point in time, which everybody is thinking about.
Ron, what about Medicaid home care? Talk to us about what's changed there and what people need to know and understand.
Oh man, yeah, the changes have been drastic. There are huge cuts to the Medicaid program, but the big one is effective October 1 of this year, so it's just a few months away, we will have a brand new 30-month or 2.5-year look back. There is a lot of horse trading with this New York State budget. And Dick Gottfried actually was right there in the heart of it. I mentioned his name before in the Family Healthcare Decisions Act. But there's a lot of horse trading done for institutional care, for Medicaid nursing home care. There's a 5-year look back. For home care, there was never a look back. What does that mean? It means that right now, if you need home care, or you've been thinking about it through the Medicaid program, right now, if you transfer assets out, you gift assets, you put assets into this Medicaid Asset Protection Trust today, you could actually go on Medicaid the first day of the next month. Right now, you could do it. And Medicaid has actually put forth all of these procedures in place, so it can be done right now. There are ways for us to submit, and we're one of the few attorneys that do this electronically directly into Medicaid. But now is the time to do this, because if you wait until October 1, there's going to be a 30-month look back for assets that are gifted away. Now, so that's why you don't want to wait. But let's say you don't need home care now, but you might need it in the future. Do the planning now, because if you can't wait like you used to. When I was in front of clients in the past, And I would say there's a 5-year look back for nursing home care, but there's no look back for home care. So a lot of clients would say, look, Ron, I'm never going into a nursing home. I may need some home care, but I'm never going into a nursing home. I'm going to wait then. There's no look back. But now I'm telling everyone, there is a look back. So even if you're not going to be doing the application now or prior to October 1, which if you need some home care, it's better to get into the system now. But if you don't, plan now. Get that 2.5-year look back, or for nursing home care, 5-year look back. Start to get that under your belts. Get it done with now, because if you need the care, you're going to have it in place. And we have a lot of clients in nursing homes who have been affected by this virus, but we have a lot of clients that are elderly in a hospital coming back home, and they're going to likely need home care. And what I'm telling everyone, do the planning now. If you need the home care, now is the time to plan. There's no look back, but there will be soon, in a few months. And if you don't need the home care or nursing home care, do the planning now, because there will be a look back. It wasn't in the past, but there will be a look back. It's in the books, and it commences October 1.
So just a couple, literally two more questions for you, Ron, and then
Sure.
we'll go to some questions here.
Sure.
What is probate?
Okay. Probate, it's hard to describe what it is, but probate is when the courts get a copy of the will and they authenticate it. And they make sure that the will was signed properly. They look at the witnesses. They make sure that everything was done to a T. They actually are very careful about it. And for example, the Queens County, almost all the counties, what they do is they make sure that staples were not removed from a will. And then so that somebody else could not take out one page and stick in another page. It says, all my assets go to my home health attendant, which we've seen, unfortunately. But the court gets the will, authenticates it. So we interface with the court. We go to the court with the will, and we're in touch. We know all of the clerks. We know the judges. We make sure that's a smooth process when we do. We have never had a will that had an issue. Did we ever have a will that somebody wanted to contest? Only a couple of times in my 40-year career. Was it ever successful? Not by a long shot. So again, that's the advantage of having an attorney do it. But the court gets the will, looks it over, even looks with a magnifying glass to see if a staple was taken out. There are questions that are asked. Family members are asked if they have any questions or want to contest that will. Who can contest the will? Those individuals who would have gotten if there were no will. Makes logical sense. So they could contest, but if there's no contest, there usually isn't, then we go through a process with the surrogates court of each individual county, and eventually the executor, that's the individual in the will that's named to manage those assets. The executor manages the assets and eventually pays the bills, pays the debts, and distributes the assets just the way the will says. And if the will says, for example, that a third goes to child A outright, fine. Third goes to child B outright, the executor will do that. And a third goes in trust for child C, because that child may have a special need, or there's a reason why the parent wants to give the assets to that child in a trust, whatever it might be. That's what the executor does. And so it's not a complicated system, but there are lots of moving parts. And again, probate is not a four-letter word. It's not so bad in New York State, but it has to be done right. But the court does get involved. Unlike when assets are held in a living trust, the court doesn't get involved with that at all with regard to the probate, and you could protect assets for all those reasons.
Great. Last question here, and then we'll go to some questions from the audience. What do I
Sure.
need to do legally if a loved one passes away?
Okay. Obviously, you know what to do, contacting the funeral home and all that. Just make sure if there's any, take a look at the healthcare proxy in case there's an organ donation situation, because when we do the healthcare proxy, we always ask our clients, do you want to donate any organs? And that has actually protected and helped lots of individuals that I know personally. So that's something to think about. Legally, I would say that right away, when you're dealing with a funeral home on the funeral arrangements, make sure that you get enough death certificates. Because when we do the probate or we do the trust administration, you want to have death certificates. And typically you want at least one death certificate for every asset that you have at a minimum, and a death certificate for the court. And it's a good idea to have a couple more, and maybe you want to show one to a life insurance company, etc. So you want to have a bunch of death certificates. Afterwards, you can get more certificates, but there's more of a long, protracted mechanism to get them. So get enough death certificates. And I would say the next thing to do, you could call Social Security, but I would say call your estate attorney, such as my firm, and we would go through exactly what steps you should be taking. We would look at all of the assets. We would look to see what assets are held by the living trust, what assets are retirement accounts, what designated beneficiaries do you have, how can we maximize the taxes on your retirement accounts in light of that new Secure Act that's out there. So we actually even do a lot of tax planning after death, and we call that post-mortem planning. And sometimes even after death, we could save on estate taxes if clients don't touch those assets right away. So what I would say to individuals, don't touch your assets so quickly. Let the attorney come in. Let's look at everything and let's see if there's not something we can do before those assets are touched. If there's a joint bank account that you might have had with a loved one, and let's say a joint checking account, you need to pay some bills, that's fine. That's fine. But if it's a significant asset, we may need to jockey some things around to protect, the survivors, save on estate taxes, and try to expedite the process. So make sure you do that, call the attorney, and we would go through asset by asset, see if there's any planning that could be done after death, and you should be in good shape. We want to know about the assets. We want to know about the liabilities. Spouses are all often worried about, my husband had debts. Do those debts get transferred to me? Not necessarily, but long-term care, if there's long-term care, a spouse is liable for the long-term care of their spouse. Upon death, the liability is very, very convoluted, but that's a conversation that we would have after death as well, so, for the surviving spouse. But those are the steps. Make sure you get enough death certificates, marshal the assets. If there's a major asset, you want to make sure that that asset is secured. If there's a business, we want to see the operating agreement of the LLC or the partnership agreement of the corporation. What type of successorship, do the documents call for? If there's a partnership, we look at the partnership agreement, and we just try to have a smooth transfer of assets and make sure, again, that a major asset is secured, whether it's a home, condominium, it could be a building. But if those assets are held in a trust, obviously it does make it much, much easier later on.
Well, I want to emphasize that there are, I'm sure, still going to be a lot of questions. We'll try to answer some, but, take down Ron's office number, which you can contact him for consultation, which is 516-466-4422. And I think everyone should see Ron's name on the screen here in the bottom left corner where he's speaking. But to spell his last name, you can get to his website, which is fatoullahlaw.com. It's FATOULLAH law.com. Again, it's Ron Fatoullah, and it's fatoullahlaw.com. We'll be emailing.
Thank you so much, Josh. I appreciate that so much.
And you guys can expect to hear from him also. But let's go through just a couple of questions here because there are many. We're not going to get to all of them, but I'm getting divorced. Should I wait to do a trust or will?
Oh my gosh. If you're getting divorced, you should really have a consultation about that. So, for example, there are ways to protect assets for long-term care easier sometimes if you're not divorced. But it depends on the circumstances. You really should see the attorney. Every situation is a little different. If you're concerned about liability, for long-term care, a divorce is an option for sure. And if you want to get divorced just because you want to be rid of a spouse that you don't feel you should be married to, of course, but there are some planning mechanisms that maybe we can't do if you are divorced. But then again, maybe a divorce could help, and everyone's situation is different. So I'm sorry, it's hard to answer that question without more details.
Yeah, I mean, I can't emphasize enough that, this is really a service to everyone here. But again, Ron's phone number, 516-466-4422. We're also, Schneps will be hosting other webinars related to both health and financial well-being. So please keep an eye out for that. Ron, here's a quick question. Do you have attorneys who speak Spanish?
We don't have an attorney that speaks Spanish, but we have someone that can actually do the interpreting. And we get that question asked often, if, for example, there's a child or whatnot that, just doesn't speak English. Yes, we could definitely arrange for interpreters. And by the way, Josh, I know you gave our Long Island number. We do have offices in Manhattan, Queens, and Brooklyn, as well as Long Island. So we're there for anyone in the tri-state area. But thank you so much.
This is an extended question, but I think you could probably answer the first part. What if you have a will designated everything, but there are now hospital bills and other debts that start to pile up?
Okay, well, the executor has to marshal all the assets. So whoever you named as executor is going to get all those assets together. And if there are any debts that you had, at the time of death, then those debts are going to have to be paid. That's just the way it goes before assets are distributed. If you make it through it, then the executor doesn't control. It's the agent on that power of attorney or yourself that are going to be paying those bills. But during a time like this, people are being understanding. The governor understands that. You can't be evicted from your apartment for a period of time now, or even your office space for not paying rent. So just get home and feel, get better. But if, God forbid, the individual dies, the executor will marshal the assets. If there are debts of the estate, those debts will have to be paid. But the executor, is part of what the job of the executor is with the attorney will argue, this is, these figures aren't right. You're charging us too much, et cetera. So this is what the executor does along with the attorney. And a lot of people creep up out of the woodwork after death and, they want to be paid for X, Y, and Z. And, many times it's just not valid. So everyone would look at that, the attorney and the executor.
Do you service the Westchester area, Ron, or clients in Westchester?
Absolutely. We're in Westchester all the time.
What about if someone owns property in another country?
Okay. Well, that is still part of your estate, and that would be dealt with. And so what we do when a client has assets in another country, we look to co-counsel in that other country, and there are treaties that that country will have with the United States, and every country has a different treaty. So we will actually work with counsel in that other country, or let's say in New York, a counsel that actually is affiliated with that country to be co-counsel to go over what needs to be done. Oftentimes, it's just simply transferring that asset into a trust and making sure that that trust that we do here in New York is also valid in that other country. Or we do something different. Every country is a little bit different.
There's so many questions here. And again, I would really emphasize people to, and I would assume that goes to states too. People are asking about other states. Yes, I would assume if it's out of the country, the states as well.
It's a lot easier if, someone, is not in New York State anymore. It's just a lot easier if we're dealing with an asset like real estate in another state. Because to be honest, I know attorneys in every one of the 50 states, and we have co-counsel all over the place within the United States.
All right. Well, again, I want to thank you so much, Ron, for being here. I know that there's many other questions, but please do reach out to Ron and his team directly. And please look out for our other Straight Talk webinars where you can find out more at any of our local news sites, including QNS.com, AMNY.com, LongIslandPress.com, BrooklynPaper.com, and SchnepsMedia.com. So again, Ron, thank you so much for your time. And
thank you so much, Josh. Thank you, Vicki. And what you guys are doing, with your papers and getting word out there to everyone has been so crucial. Keep up the great work. Thanks so much for having me.
Well, and be well to the audience. Everyone take care.
Thank you. Take care. Bye-bye.